Based on the fact that Fred Rispoli has chosen this particular day as the likely date for the final ruling, it is clear that advocates of Ripple are feeling optimistic about the possibility of a similarly good outcome. Rispoli, on the other hand, stated that it was highly improbable that the SEC and Ripple would reach a pre-judgment settlement, despite the fact that there may still be some topics that are open for negotiation. In accordance with the precedent set by Judge Annalisa Torres, Judge Amy Berman Jackson of the United States District Court for the District of Columbia has partially dismissed the charges brought against Binance by the Securities and Exchange Commission in relation to the selling of BNB on the secondary market. The SEC was found to have failed to produce sufficient evidence to demonstrate that the secondary market sales of BNB tokens on cryptocurrency exchanges constituted securities transactions, according to the decision made by Judge Jackson. A further allegation made by the SEC that Binance's fiat-backed stablecoin BUST is eligible to be classified as an investment contract was also dismissed by the court. Judge Jackson underlined that handling the digital asset market on a case-by-case, coin-by-coin, court-after-court basis resulted in inconsistent outcomes and continual ambiguity. He said this because it leaves the industry open to interpretation. This verdict makes reference to the decision that Judge Torres made on the same date the previous year, which indicated that XRP is considered a commodity when it is sold to the general public. It was declared by Judge Torres in her summary judgment that Ripple's institutional sales of XRP comprise the unregistered offer and sale of investment contracts, which is a violation of Section 5 of the Securities Act. This decision had a tremendous impact on the Ripple community, which resulted in an increase in the price of XRP by more than 100%. Ripple, in response to the ruling made by Judge Jackson, issued a notice of supplemental authority, which strengthened the legal viewpoint on the classification of digital assets during the proceeding. In the files that they have produced for their different legal disputes, Coinbase and Ripple have recently brought attention to the lack of clarity that exists around their respective cryptocurrency regulations. Both businesses contend that the regulatory framework is unclear, which makes it difficult for them to conduct their activities and generates legal issues. In recent court filings, Coinbase and Ripple have brought attention to the regulatory uncertainty that exists. In the files that they have produced for their different legal disputes, Coinbase and Ripple have recently brought attention to the lack of clarity that exists around their respective cryptocurrency regulations. Both businesses contend that the regulatory framework is unclear, which makes it difficult for them to conduct their activities and generates legal issues. Coinbase claimed in a court statement on July 2 that Binance is also in agreement with the necessity of the Securities and Exchange Commission engaging in rulemaking addressing digital assets. Coinbase stated that legislation is necessary because the Securities and Exchange Commission (SEC) has adopted an unprecedented and wide interpretation of securities laws. The CSE has never provided a clear explanation for this interpretation, but it is currently attempting to implement it retrospectively throughout the digital asset market through aggressive enforcement proceedings. Ripple also took use of Binance's recent court success in order to criticize the inconsistent regulatory approach taken by the SEC to argue for the requirement of formal rulemaking. The notification emphasized that intangible digital assets did not easily fit into the Howey test framework, which is a 7-page ruling that is used to define security. Ripple has voiced its disapproval of the Securities and Exchange Commission's SEC dependence on court cases as a means of regulating the industry, adding that this could result in uneven outcomes and unclear direction for market participants. In response to Ripple, the Securities and Exchange Commission places an emphasis on fair notice but omits a discussion on secondary market transactions. In response to Ripple's notice of additional authority, which was issued on July 3, the Securities and Exchange Commission (SEC) criticized the SEC's regulation by enforcement strategy and brought attention to the absence of regulatory clarity. The CSE referenced a recent ruling from Binance. Ripple's attempt to cite the Binance case was rejected by the Securities and Exchange Commission staff, with George Tainri-Riro of the SEC describing it as completely irrelevant to current motion. According to the agency's argument, Ripple failed to include an essential component of the Binance verdict, which rejected the fair notice position and emphasized that the SEC implemented a federal securities statute that has been in effect for a long time. Additionally, the ruling acknowledged that the cryptocurrency sector had been informed by the SEC's Day report from 2017, which was published prior to the majority of Ripple's XRP sales. The Binance ruling is a significant loss for the exchange, said John Reed Stark, a former official with the Securities and Exchange Commission. The Securities and Exchange Commission commissioned its reaction to Ripple on the fair notice component of the Binance ruling. In the filing, the Securities and Exchange Commission pointed out that Ripple had left out the pertinent portion of the Binance order, which had rejected the reasonable notice defense, which was comparable to the decision that this court had made in the past. The idea of fair notice is a legal principle that ensures persons are fully informed of any claims or legal actions that had been taken against them. This principle gives individuals the opportunity to respond or defend themselves, as well as the additional information that they require. Regarding the issue of fair notice, the Securities and Exchange Commission on having provided the required notice, the most recent letter from Ripple completely ignores the one aspect of Binance that can possibly have any bearing on the remedies motion. The argument that the fair notice concept offers a defense against liability is rejected in this section of the opinion, just as it was rejected by this court. Since the Dow report was published in July 2017, which was before to the vast majority of Ripple sales that are at issue in this lawsuit, the CC has been putting the sector on notice because of it. The SEC came to the conclusion that the Binance court had taken into account the fact that the defendants were aware that the SEC could take action against them. This is analogous to the situation in which Ripple received particular notice of the dangers involved in its actions based on legal advice, but nonetheless determined to proceed. Despite the fact that the SEC placed a strong emphasis on the fair notice issue, it did not address the secondary market transactions involving Binance Coin or the ruling regarding the programmatic sales of XRP. Bitcoin XRP at a crucial crossroads as a result of Ripple's decision to deny the SEC's offer to decrease its penalty to $102.06 million. XRP is currently in a precarious position. Considering that Ripple and the XRP coin have already suffered legal expenditures totaling more than $200 billion, this ruling may have a huge impact on both areas. Over the past week, the price of XRP has decreased by 1.5, and it has dropped by 4.63 in the last 24 hours. The current price of XRP is 45 cents. The trading volume reached $862 million, representing a 14 increase from the previous level. If market sentiment continues to be optimistic, there is still the possibility of further appreciation. During the month of May, the Securities and Exchange Commission stressed the significance of the financial state of XRP in its legal arguments, stating that the analysis of the court must identify suitable remedies. The information that has been provided is not intended to be trading advice. There is no responsibility for any investments that are made based on the information that is provided on this page. Before making any decision about investments, we strongly advise conducting independent research and consulting with a knowledgeable professional.